Hi, my name's Keri Burnstein. I'm one of the attorneys at the law office of Catherine Wayne Spindler, located in Milford, Michigan. As a family law practitioner, we get lots of questions from potential clients. One particular question that we get asked very often is regarding the first right of refusal or the first right of caretaking. What this means is it's a term that goes in a judgment of divorce regarding parenting time. If one parent who has the custody or parenting time is unavailable, then should the other parent get the first right to be the caretaker for that child during that time? Oftentimes, parents think this would be best and they want this language in their judgment. And sometimes this is right for the parents, but oftentimes it's not. And as an attorney, I need to discuss this with my clients and explain why not. Let me give you a few examples, specifically located in the Family Lawyer magazine from February 8th, 2022. The first right of caretaking clause, some issues and abuses to it. Here's an example. A parent insisting that a child may not attend an after school or daycare or even a camp program while the custodial parent is at work because the working parent isn't the one caring for the child and the non-custodial parent, meaning the one who doesn't have the parenting time, is available. This often causes big problems for the child because they may want to go to camp or they may want to go to daycare, and this isn't what was really intended for this clause to mean. Another example, a parent stating that a child can't spend an overnight with a friend or a relative or even time with a step parent because the custodial parent won't be there. Thus, this triggers the first right of refusal or first right of caretaking clause. Again, not necessarily what was intended when the parties put this in the judgment. The idea wasn't that the child couldn't go to daycare or couldn't go to camp or couldn't go to a friend or a family member's home. The idea was if the parent was unable to be there for that child, then the other parent should be asked first to be the babysitter, the caretaker of the child at the time. This often causes many problems for parents, especially those who are still struggling to get along after a divorce. It's important to discuss this matter and make informed decisions about whether or not this is really the right language for you in your judgment. Here at the law office of Catherine Wayne Spindler, we're happy to answer any questions regarding the first right of refusal or first right of caretaking.